All right. Welcome, everyone. Good afternoon and good morning, depending on where you are. And thank you for taking the time to join us for today's webinar. It's so good to be here. We did not have webinars in September and October because of the conference preparation. And then, of course, our annual conference took place in October. So it feels like it's been forever, and it's good to be back here for a webinar. My name is Tina Barr, and I'm the Director of Training and Education for the National Association for Civilian Oversight of Law Enforcement. NACOL is an organization that works to create a community of support for independent civilian oversight entities seeking to make their local law enforcement agencies, jails, and prisons more transparent, accountable, and responsive to the communities they serve. A part of that effort is our webinar series. Since 2015, NACOL has worked to bring you information through our webinars on effective practices in civilian oversight, innovations in the field, and efforts to reform the criminal legal system. So before we begin, I'd like to go over a few logistics. First, you do have the ability to turn on your captions for this webinar using the caption button at the bottom of your screen. And given the large number of audience members today, everyone has entered the webinar in listen-only mode. So you do not have your chat feature. However, you do have the Q&A feature if you would like to ask questions. And so please use that. But do note that in order for the speakers to get through all the information that they've prepared today, they'll respond to questions after their prepared remarks. But please do post the questions as they come to mind. Everyone in the audience does have the ability to upvote questions by clicking the thumbs up icon beside questions when they are posted. Upvoting moves particular questions up the queue, and so that will help us to address the most pressing questions in the short time we have together today. To allow more time for questions and direct engagement, though, we do have an optional 30-minute discussion with the speakers immediately after the webinar. And so if you choose to attend that, I will post the link to that discussion. It's a separate Zoom link. I'll post that in the Q&A for you towards the end of the webinar. And finally, as a reminder, today's webinar is being recorded and will be available to registrants only for 3 months after today. And so within 5 days of this webinar, you'll receive an email with information on how to access the recording, as well as a link to the PDF version of the slides that are being used today. And so now that the details are out of the way, I'd like to move our attention to the webinar, the importance of a discipline matrix in policing and civilian oversight. To save time, this is an abbreviated description of the webinar. The full description is on the NACOL website, however. Our speakers today will discuss the opportunities and challenges faced in trying to ensure fair and consistent police discipline that satisfies community expectations and supports effective and constitutional policing. They will discuss their experiences in creating and sustaining disciplinary matrices in New York City and Denver, and provide guidance on best practices for creating and implementing disciplinary matrices to improve police behavior and culture going into the future. Now it's my pleasure to introduce the speakers. Today we have Ms. Heather Cook and Dr. Richard Rosenthal with us. Ms. Cook is Assistant General Counsel and Deputy Chief of Investigations at the Civilian Complaint Review Board in New York City. In this role, she provides legal advice and training to board members, supervises multiple teams of investigators, and works on other agency legal matters, such as rulemaking and litigation. She developed the CCRB's first discipline framework and represented the agency as a member of the NYPD Discipline Matrix Working Group. Prior to joining the General Counsel's office, Ms. Cook was part of the inaugural class of prosecutors hired for CCRB's groundbreaking administrative prosecution unit. For 5 years, she prosecuted police officers in disciplinary infractions related to excessive force, abuse of authority, discourtesy, and offensive language. Ms. Cook also spent 6 years as a prosecutor in the Bronx County District Attorney's Office. She is a 2006 graduate of the City University of New York School of Law, where she was a criminal law teaching assistant and president of the Moot Court Board. Ms. Cook is admitted to the bar in New York and Connecticut and is a published law review author. Dr. Richard Rosenthal is a former Los Angeles County public corruption prosecutor who has been credited with uncovering the Los Angeles Police Department Rampart scandal and who has served as the director of Portland, Oregon's Independent Police Review Division, the first independent monitor for the city and county of Denver, and the first chief civilian director of the Independent Investigations Office of British Columbia. Dr. Rosenthal received his PhD in criminology from Simon Fraser University in 2021, with an emphasis on civilian oversight of the police. His PhD dissertation evaluated the implementation of the federal consent decree in Seattle, Washington. Dr. Rosenthal has served on 2 federal consent decree teams in Cleveland and Seattle as a subject matter expert on police oversight and accountability, and is currently serving as the independent police auditor for the city of Pasadena, California. While working as the independent monitor for Denver, Dr. Rosenthal was integral in helping to create the Denver Police Discipline Handbook and Matrix and the city's community police mediation program. Dr. Rosenthal is planning to, quote, retire, unquote, from oversight at the end of this calendar year to focus on writing fiction and nonfiction books and to operate his hobby farm with his wife near Vancouver, British Columbia, where they grow, raise, and sell fresh lavender, and honey. That sounds delightful. So, without further ado, I am going to turn things over to our speakers.
Okay, I think I'm up first, so I am going to share my screen. Share. Okay. And just make sure, can everybody see that?
Yes.
Okay, great. Thank you, Tina. All right, so I'm going to go through this pretty quickly and we can deal with questions at the end. I'm going to start by talking about the importance of having a discipline matrix or a discipline framework for a civilian oversight agency, and how we went about it here in New York City and how that helped us sort of get a seat at the table, if you will, when the New York City Police Department began drafting their disciplinary matrix. So one of the things that was problematic that I noticed way back when we started doing this in probably 2015, 2016, is that our city agency, we had a lack of consistency in our discipline recommendations. One of the biggest problems is that our board comes in at staggered 3-year terms. So we had a number of different chairs with different priorities, a number of different board members with different priorities, and our discipline recommendations were back and forth depending on, a lot of times, the priorities of the different chairs. Because we have no final authority over discipline. So basically we make a recommendation to the police commissioner at NYPD and then they take it, they ignore it, they do what they will. So our final agency findings are merely recommendations. So as you can see here, I added this chart just to show you over a 5-year period from 2013 to 2018. This is our substantiated charges as a percentage of full investigations. The biggest change in 2013 can be explained by the fact that that was the beginning of the administrative prosecution unit. And the board basically felt like, okay, the jurisdiction of the administrative prosecution unit is any cases that we vote charges and specifications, as opposed to training or conditional discharge, different reprimands, instructions. So the board basically decided we're going to give the APU a lot to do. And they started voting a lot of cases with charges and specifications recommendations. You can see it sort of went down a little bit. Sorry, I apologize. It went down a little bit over the years as we got different chairs. Some chairs thought that discipline would be, that it would be better for community relations if discipline was less about charges and was more about training. And we just said, you know, when looking at this, when new board members come on, because every year we get new board members, basically, as some rotate in and some rotate out. And new board members would come in and they'd say, do you have anything you can train me on about what I'm supposed to recommend? And we really didn't have it. And that was really detrimental when we looked at this sort of 5-year span of how we were kind of all over the place with our recommendations. So what we decided was we should come up in-house, internally, with some sort of a discipline matrix or a discipline framework. We wanted to have consistent and fair discipline recommendations for both civilians to understand and expect, and for MOS, for members of service and officers to understand. We wanted to say, this is what you can expect from the CCRB, right? And we didn't really feel like we had been doing that. One of the big things that we got pushback on from our board members, however, was that they didn't want it to be binding. And there were a number of reasons for this. But, when you're starting something new and they had never worked within a discipline framework before. And so there was a little bit of pushback, and we said, okay, this is going to basically, instead of calling it a matrix, we called it a discipline framework. And we said, this is a framework through which you should evaluate the cases. You run it through this framework, and basically it should give us, if everybody follows the framework for the most part, we should have more consistent discipline. And it will help the new board members understand, sort of on a scale of most serious to less serious, how they should be looking at penalty recommendations. So this is sort of what we came up with. And I like to kind of relate it to, it's a little bit of the old choose your own adventure, or the Plinko kind of, if you will. We started with charges and specifications because that is the most serious. So we basically said, once the board substantiates, and again, I want to be clear, this didn't come into play, this discipline framework didn't come into play until after the board had already substantiated an allegation. So once the board substantiated an allegation, then we moved on to the discipline framework. It was to have no bearing on whether or not the board found misconduct initially. It was only to come into play when we were dealing with what penalty should we recommend to the department. So we began our discussions and we said, let's start from the top to the bottom. What are our most serious substantiated allegation types? And you can see, I list them here. We started with 6. At the time, this was our jurisdiction. We've since expanded jurisdiction to include false official statements, which would also fall in here. We had chokeholds. Obviously, they were prohibited by the department. Strip searches, very serious, so obviously than a street stop or search. Warrantless entries, just based sort of on the nature of the Fourth Amendment, where in your home, it's a higher violation of someone's personal freedoms. And then I just want to spend a second on offensive language. So at the CCRB, we have 2 categories. We have discourtesy and offensive language. Discourtesy is best understood as basically curse words, your general curse words, or if you tell somebody, shut up, if you say to somebody, you're ugly, something like that. That's discourtesy. And there is case law from the New York City Police Department, from their internal discipline tribunal, that basically says there are certain times during stressful street encounters when you're under the adrenaline of it, where curse words may come out, where discourteous statements may come out. They may serve a law enforcement purpose. It's a crowd is coming in and the officers are screaming, get the F back, situations like that. Then there's a second set of language that should never, ever, ever be used. And this is what we call offensive language. And that is basically things that would involve, basically words that would describe protective class, the N word, the F word, making a comment on someone's disability, someone's housing status. And these are things that never, ever, ever serve any law enforcement purpose. They should never come out of an officer's mouth. And we felt like, yes, it's language, but at the same time, it's very serious, right? So we included it. Excessive force with serious injury speaks for itself. Sexual misconduct speaks for itself. So as you can see, the way we did it was we told the board members, does this fall into one of these 6 substantiated allegation types? Yes. Okay, then the general recommendation should be charges. However, if it doesn't fall into one of these categories, let's go now look at the officer's history. Does the officer's history give us any indication that maybe this isn't the first time the officer's been doing this? Is there something else in the officer history that tells us this is somebody maybe we want to be taking a second look at, that despite the conduct here, we want to bump it up and make it a little bit more serious based on that history? And if not, we had the case totality, right? And we had situations where, and the best example of this one was we had a situation where an officer pulled somebody over for a traffic stop and wanted to get his license, and the civilian would not give the license. And the officer took his thumb and pressed it into the eyeball of the civilian and basically said, no, I didn't learn that at the academy, but it's a good tactic to gain compliance. And obviously there was no permanent damage. It wasn't serious physical injury. But this was totally and completely inappropriate. That's sort of the case totality example. That would lend itself to charges. If not, when you get to the bottom, then we choose between the CDB and CDA. So one CDB is a forfeiture of 5 to 10 vacation days. CDA would be 0 to 5. and then training and instructions. And so the board was basically given this non-binding framework, right, to say, work your cases through here, and let's see where that gets us. So the board in 2018, after going through all the stats and coming up with this, the board adopted the framework. They said, we will give this a try for 6 to 12 months, and let's see what happens. I did a public presentation at our monthly board meeting, and we told the public, we told the civilians, the NYPD, the unions, everybody, we're going to start with this framework process. This is what our framework is, and here's what you can expect from us. So if you see 12 months later, what you have on the left column is the average, the 5-month average from the first slide. And then you have what we did in 2018 when we were doing the pilot program. And these were all of the penalty recommendations. So we have charges, which is the most serious, command discipline, which is, as I said, the forfeiture of 0 to 10 vacation days, formalized training, instructions, which is sort of like a reprimand. And so we were, the charges went down a little bit, but the others stayed relatively consistent. And the most important part was it gave us this ability to say, we know now, we have an idea now, what is our most serious, what is our less serious, and how we're going to recommend discipline to the NYPD. Now, meanwhile, while we went through this, while we were publicly saying, hey, we're going to be using this discipline framework over here, the police commissioner at NYPD created a blue ribbon commission to study the NYPD disciplinary process. In January of 2019, they came out with a report, and one of the main recommendations in the report was that NYPD create a discipline matrix. This was on the heels of Denver, which Richard will talk about, on the heels of Los Angeles, and a few other cities coming out with discipline matrices. The NYPD invited us to be part of their discipline matrix working group. We joined, we went in, and we basically said, listen, this is a great opportunity for us to get a seat at the table. We don't often get a seat at the table because the police commissioner has final authority over all of the dispositions. This was one of our shining moments where we were going to get to go in there and tell them, this is what we do, this is how we do it, and this is why we do it, and this is why we think you should do it. Now, one of the things to remember is that for the CCRB, my agency, we only have jurisdiction over certain types of offenses: force, abuse of authority, discourtesy, offensive language. We have now false official statements and racial profiling. What we don't have jurisdiction over is a slew of other things that NYPD deals with, like domestic violence or being unfit for duty or improperly storing weapons, things like that. A lot of internal issues that don't involve civilians. So they had an enormous task ahead of them. And it seemed really appealing to them to say, you know what? For these allegations that CCRB is going to investigate anyway, they have a really good rationale for what they did. The idea of maybe just plucking their framework and they're taking their stats and their rationale and plopping it down to create a huge section of our matrix might make our lives a whole lot easier. So sure enough, they published a draft of their matrix in August 2020, and it did incorporate a lot. When I say a lot, it basically lifted and put our discipline framework, data, and rationale into the matrix for all of our FATO allegations, for all of the allegations that CCRB dealt with. Interestingly enough, it wasn't as comprehensive. So they didn't cover all of the categories that we cover, but they covered the basic categories. So we were then able to say, okay, we can infer from, one category what something else might be, and we could extend the matrix in that way. The NYPD published a draft matrix, and they agreed to accept comments for 30 days, but then scheduled no public hearings. So instead, we held the public hearing on the draft matrix in September of 2020, the following month. We heard from advocates, we heard from the unions, we heard from civilians, we invited everybody, we gave our own testimony. And then we compiled everything, and we wrote a letter to the police commissioner, and we said, here are the findings from our public hearing, and here's some recommendations on what we think you should do with your draft matrix. So January 15th, 2021, NYPD's first discipline matrix is released. Shockingly to us, the overall penalties were actually initially higher than our CCRB framework, which was amazing for us. Like, we felt like we were there, we sat at the table, we gave them our rationale, and they actually took it. And that really just felt really good. it felt like a minor win in that moment. There were still many problematic issues. The matrix was a lot more obviously detailed than our discipline framework. It was binding, and it had aggravating and mitigating factors, which we kind of put that in our totality, but they specified them. The problem was a lot of the normal job responsibilities were mitigating factors. So like a mitigating factor is the voluntary candor of the officer. That should be sort of understood. De-escalation by officers should be attempted every time. They said that they would provide deviations from the matrix in writing. They would explain to us why they were deviating if they were deviating from the matrix. We basically get letters that say it's in the best interest of the department, so we're going to deviate from the matrix, with not much more detail than that. And also, much like how our rates went back and forth before we had the framework, the different police commissioners, and we've had a few in the past few years, they've had wildly different deviation rates. So some have just sort of followed the matrix for the most part, deviated here and there, and then others have come in and said, nope, I don't like any of this, and just deviating left and right. So while it definitely, the idea of it is great, and it's still better than not having one at all, there's still many holes in this process and many ways for the lack of transparency and the lack of consistency to sort of rear its head. The NYPD makes a big deal about the fact that the matrix is based on a progressive discipline, but yet the CCRB is still not given full officer disciplinary records. So we are given what's called a summary of employment history instead of the Central Personnel Index, the CPI, which has their full disciplinary history. And the biggest reason why this is an issue is because when we talked earlier about the command discipline, 0 to 5 days vacation or 5 to 10 days, a CDA, which is still significant discipline, that automatically comes off of the officer's CPI after a year. And they can also petition to get a CDB off of their CPI. So there could be actual significant discipline history that just disappeared from their CPI that they still have a record of, that we don't have a record of, that wouldn't come over in the summary of employment history. So we'll get a summary of employment history that says this officer is clean, this officer has no prior disciplinary history, when in fact the officer maybe did do the same car search a year and a half before, but they got a CDA for it or they got training for it, and then it came right off of their disciplinary history. So we still have issues. Obviously, nothing is perfect. But we decided we would follow the initial matrix for 1 year with no deviations. That was our commitment to NYPD. We said, we are committed to this matrix. We will follow it for 1 year. And then at the end of the year, we'll figure out where we stand and if we're going to continue moving forward. So we had a slight delay on our part. We had to program our voting application. We had to train new board members about the matrix, the new features of the application, but we did it. We followed it for a year. And I will say we still to this day basically follow it. After a year, we decided we would allow deviations because there were just times where board members were like, this is too rigid. Remember I said in the beginning, one of the things they really pushed back on was not having any discretion at all. And they felt like following the matrix to the letter gave them no discretion. So they decided we do want to deviate. We make them explain why they're deviating anytime they do that, though. There have been 2 subsequent updates to the NYPD matrix, one in February 2022 and one in September 2024. For both of the updates, they just sort of came one day out of the blue. There was no comment period. There was no warning. It was just up, a new edits to the matrix are out. The penalties, which we were so excited about in the beginning because they were so much higher than our penalties, have consistently been coming down, getting reduced for certain things. And so, we follow it, as I said, but we deviate as appropriate. And again, nothing in any of the 2 updates has confined the police commissioner to any additional restrictions in terms of deviations. So the police commissioner obviously has final say over everything, over all of internal discipline, but there are no additional guidelines as to when or how they can deviate. So What I just want to sort of impart on everybody from an oversight perspective is that if you don't have a discipline matrix or any sort of discipline guidelines, and you are an agency who recommends or imposes discipline, I really encourage you to create one yourselves if your local department doesn't have one. It has been really great for our agency in terms of consistency, fairness, legitimacy. If the police department doesn't have one and you have one, it's very helpful. Everybody knows what to expect. And it makes the operation of your agency easier. It makes training new board members easier. It makes training staff easier. It lets everybody know what to expect. If you don't recommend or impose discipline and your police department does not have a matrix, obviously, Richard and I would both say strongly advocate for the adoption of one. Like I said, even with all of its faults, it's still better that the NYPD has a matrix now than before. And if your police department agrees to develop a matrix, get that seat at the table. That was really, really important for us. And I think had we not been there, leaving our jurisdiction up to NYPD to determine, I think we would have I don't think we would have been as happy or as satisfied with the recommendations that they would have made for our FADO categories. And again, like I said, a discipline matrix, a discipline framework, binding, non-binding, none of these will be the perfect solution. There's always going to be wiggle room. There's always going to be deviations, but it is still so incredibly important for law enforcement oversight as an oversight agency, as well as internally at a police department. So with that, I am going to stop sharing my screen. I promised Richard I would not go over my 20 minutes. How did I do, Richard?
You did great. Thank you.
Awesome. Okay, so now I will turn it over to Richard.
Great. I'm going to try and share here, and I think this has worked. So actually, I was quite thrilled to have an opportunity to present with Heather, and I specifically asked to go after her. And large part of it's because New York is obviously, the largest police department in the country. It's a massive oversight office, independent investigation model. And then I wanted to present from the perspective of Denver, a mid-sized city with a monitor model, but so that everyone can really see that it applies, this concept applies regardless of which model of oversight you've got. And it really does, as Heather said, a lot of it has to do with getting a seat at the table while developing any kind of matrix. So I did the work, and whoops, let me see if I can, I'm not sure how to move. Oh, there we go. Perfect. So very similar experiences between Denver and New York in the sense of we had a problem. And the problem was we were trying to ensure fair and consistent discipline, but in Denver in particular, there was something called comparative discipline. And what it meant was that basically anytime the department gave an officer a break, the department had to give every officer a break. So over time, over the years, discipline kept getting pushed down, 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 until finally they had an incident where an officer actually went into a cell and threatened a handcuffed prisoner with a gun to her head, telling her to shut the F up. It was caught on video, audio. The officer, was sustained for excessive force, sustained for lying, was terminated, and then civil service brought the officer back. And the real issue was the civil service decision was not outrageous because the discipline that had been imposed over the years kept going down, down, and down. And if it was actually compared with other discipline, the officers weren't terminated. So we realized we had to have a reset. And our problem as we faced it was, first, how can a department ensure that the police culture of the department understands expectations and consequences? How can a department ensure discipline is fair and consistent? How can a department ensure that it will not be embarrassed by discipline that's too lenient? And how can the department ensure that its rank and file will not become disillusioned by discipline that's perceived to be too harsh? One of the issues we had also in Denver at the time was that officers would lie when the truth would do, because they were so scared of being disciplined for whatever it was that they had done. They had no clue what they were going to get, so they'd lie because they just wanted to avoid being sustained. So it created a culture within the department that was inconsistent with constitutional and effective policing. So obviously the potential solution was a matrix to provide some objective criteria to ensure fair and consistent discipline. We also had the problem that discipline was recommended from, it started with lieutenants, then went to commanders and made its way up the chain of command, and was wildly disparate. And it really was based upon individuals' own philosophies on what discipline should look like, or when it should be imposed and when it shouldn't. And so the problem is when you have a department that size, over 1,000 officers, and you have that many members of, that many lieutenants and commanders and captains, everyone has a different idea, and everyone puts their idea into the mix. So once it got to the chief or to the director of public safety to make the ultimate decision, they'd have widely disparate recommendations, and they'd have to just figure out what they wanted. When I started as monitor, I actually had the authority to recommend discipline, just like any police commander or assistant chief. And what I realized was I was basically picking it out of the air. This feels like 10 days. Okay, no, this one's really serious. This feels like 30. And so I too realized I needed some kind of criteria, something to tell me what would be the appropriate level of discipline to impose. So it needs to take into account the actual violation as well as the officer's background. It needs to provide officers with a clear understanding of the expectations and consequences, and it needs the buy-in of the community and the rank and file. And one of the key things that I point out here is just like no two civilian oversight or law enforcement agencies are alike. We're snowflakes, right? Because it depends on the culture of the organization or of the jurisdiction, the political will, etc. So there's not necessarily any specific best practice in what the organization should look like. It's a little bit similar in a disciplinary matrix because different communities have different expectations, and different departments have different cultures, and there really are potential variances, not just in policy, but in under what circumstances you should impose what type of discipline. So you need the buy-in of the community as well as the rank and file for this type of thing to work. So we created a discipline advisory group to come up with the matrix. And this is one of the most important points, I think, in the presentation is you need to do it right. This is not the type of thing where you can just sort of take a matrix from one place and put it down in another and say, we've done our job and now we're going to do it. It's actually really important that there is collaboration, that there is work done to determine what should this look like for our community, what are our expectations and needs. And so it requires multiple participants of different involving different stakeholders. And I'll give you an example that in Cleveland, I was part of the federal monitoring team, and I was able to bring in parts of the discipline matrix to Cleveland. But one of the things that was most disappointing to me was nobody was willing to go step back and say, we're going to create a work group to come up with the policy. Instead, the policy was really top down. Came from the monitoring team, came from the command staff. There was some conferral, there was conferral with the union, but really it wasn't holistic. And as a result, I think the Denver matrix has been and always will be stronger within Denver because we created a discipline handbook in addition to the matrix. And so let me explain first, the participants in the disciplinary advisory group. We had members of command staff. We had internal affairs leadership. They were able to tell us sort of the history and what had happened in the past and what their philosophies were on what should happen in the future. We had rank and file members as selected by the chief. We had union leadership and lawyers. This was so important. If we just did this without union input and then foisted it upon them, then what you end up having is grievances, you end up having no buy-in. Having the union at the table and their lawyers at the table was extremely helpful. And they had an interest in it because they saw that discipline was inconsistent and unfair. And they were consistently appealing discipline. They wanted for their own members there to be some kind of fair and consistent discipline. Now, obviously, we have different philosophies on some of what discipline should look like in some cases, but interestingly enough, we all had the same goal, just not necessarily agreements as to exactly where it should go, but ultimately the decision was made by the Director of Public Safety as to which way to go. We had the Civil Service Commission executive director on there. We had members of the city attorney's office, and we had the community oversight board chair and vice chair. And I somehow I left out me. So I was pretty much vice chair of the advisory group, along with the director of public safety, who was the chair. And I do remember this was a 3-year process. We met every month for an afternoon, an evening, what have you, and kept meeting and meeting, and then writing and writing and writing. And I do remember we had come up with the concept of the matrix, and I wanted to go with it. I wanted to run with it. And then the then director of public safety, Al LeCabe, said, no, we need a handbook. We need to explain the philosophy behind our discipline. We don't just need a matrix. And I remember I was very resistant at first. I thought it was going to take way too long. I ended up writing a big part of the handbook along with the deputy director of public safety and one of the deputy city attorneys. We ended up writing a very long handbook, and it was the best thing we ever did. And after, wow, going on 25 years in oversight, I still feel that this was one of the greatest successes of anything we did, because we created something. We were able to really explain philosophy and concepts and processes and put them in place so that the matrix would outlast any one individual leader of the department. So one of the other things we did as part of the handbook, and we put them in appendices. If I were to do it today, they would be in the main structure. This would be the most important part of any handbook. But we talked about our philosophies on important issues relating to discipline. Untruthfulness, that's a big one. We actually divided it up into what we called big lie and little lie. And it's really was premeditated lies and non-premeditated lies. So a lie to a dispatcher. Oh yeah, we're on our way, but we're actually finishing our big gulps in 7-Eleven. That was an actual case. That became an inaccurate statement. And as I'll explain later, a category D and a 10-day presumptive suspension. Whereas an intentional and deliberate lie during the course of an investigation or such. So for example, if you're actually then called into internal affairs and you're required to tell the truth, and then you lie intentionally and deliberately, well, that's a deceptive act, that's a category F, and that's presumptive termination. So we had to discuss that. What does this look like? Because there's some departments that say, oh yes, we have a zero tolerance policy for lying, and the vast majority of those departments are lying when they say that. Because there will be officers who will lie about something and they don't want to terminate them, so they won't sustain them for it if in fact there's a zero tolerance for lying. They'll just find an excuse why they don't believe they can prove the officer lied. So you have to really talk about and figure out what are the expectations of the community and the department relating to truthfulness of officers, and are you willing to tolerate an officer off the cuff, yeah, I was late because I got a flat tire, when in actuality they overslept. Do you want to terminate them for that or not? Usually it's the smaller departments are the ones that can get away with saying, yeah, we have no tolerance for that. The larger ones usually have to work something out. Criminal acts. At what point is the criminal act such that it deserves termination versus some lower form of discipline? What about if it's uncharged or charged? What if the officer is convicted or acquitted? All things that you have to put in the handbook so people can't come up with their own ideas about what should happen there. We need to have a discussion of use of inappropriate force, of sexual misconduct, under what circumstances that would fall within a category F, which is most, if not all. Conduct prejudicial could be anything that just embarrasses the department. It could be from walking your dog off leash to something significantly serious. And we had to kind of figure that out and talk about that in our handbook. Careless handling of firearms. That was one of the most interesting ones, because we had to talk about, all right, you have an accidental discharge, nobody gets hurt, what happens? You have an accidental discharge, somebody gets hurt, what happens? You have an accidental discharge, somebody dies, what happens? Different discipline for each one, even though the actions are the same. And finally, driving violations resulting in either injury or death, or impaired driving or driving under the influence with a traffic stop. with a traffic accident, with property damage, with injury, with death. How are they differentiated? And that's all discussed in our handbook. We created a DAG, a Disciplinary Advisory Group Standing Committee, to evaluate the matrix on a regular basis. And that included the director and deputy director of public safety, the independent monitor, which I was, and a representative of my oversight board, chief of police and a deputy chief of police, 2 officers of each command rank, so 2 lieutenants, 2 captains, 2 commanders, 1 representative of each employee organization, 2 union reps and a union lawyer, Civil Service Commission executive director and a deputy city attorney, and then some additional community members are chosen by the public safety director to make sure it was a balanced group. So this group would regularly meet, discuss, evaluate cases, see how the matrix was being applied, and then update it accordingly. These do need to be living documents, to believe that you can come up with a matrix that is 100% workable from the very beginning. It's not going to happen. They're living documents that need to move along with the culture of the organization and the expectations of the community. So in essence, what we came up with categories, levels A through F, A being the most minor violations, F being the most serious. We had discipline levels, which I'll show you in just a moment. We had a mandatory progressive increase in discipline level. So if you had committed within a certain period of time a violation that was either of similar severity or even more severe, you would be jumped up in their discipline level. We had presumptive penalties. We specifically laid out mitigating and aggravating factors, which was actually really important. We had found that in the past, they had used, some commanders had used as a mitigating factor, for example, well, the officer has a family they need to take care of. Well, guess what? That meant that, male officers with spouses who didn't work and kids got lower discipline than single officers or female officers who potentially had a working spouse. So it was just utterly biased as a factor in mitigation, utterly inappropriate. And we had to basically lay out, these are what are appropriate factors in aggravation or mitigation, and these are what are not. We put in definitive mitigated and aggravated penalty ranges, which I'll show you in a second. We provided for special circumstances. There were some circumstances that would warrant going outside the matrix, but it would have to be documented, and the expectation was it would not happen often. Generally, we provided consecutive penalties for each separate type of violation, and then we put in a maximum suspension of 90 days. Now, that's different. A lot of the places now have a 30-day or 60-day maximum suspension. We actually had a year. We had officers who was suspended for up to a year without pay, which was a huge problem. So when we went to 90 days, we brought it down. It also gave us a more leadway in really differentiating between conduct and discipline. But that's, again, another decision that each agency has to make, each jurisdiction. What should the maximum suspension without pay be in lieu of termination? This is what the penalty table looks like. Now, in Denver, they have fine days, which really just means you lose a vacation day. So you've got a vacation break, okay, you got to give up a day. So that's obviously less than suspension without pay. And then there are opportunities for demotion as well that are outside of the matrix, and it leads to termination. But you can see as you go up in disciplinary levels, the presumptive penalty goes up. The mitigated penalty goes up, the aggravated penalty goes up. And in the end, if you get to discipline level 8, presumptive penalty is 90 days with mitigation. It's termination with mitigation, it's 90 days. And you have a variety of potential penalties depending on the discipline level. So this, again, we had some real debates whether we wanted mitigated and aggravated penalties or just presumptive. We went this direction again because it seemed to give people a little bit more guidance on what to do if you had mitigation, if you had aggravation, if you have extraordinary aggravation, extraordinary mitigation, you can go outside of the matrix. And I'm going to go through this real quickly, but you can see category A, we actually had very extensive rules and regulations. And what we ended up doing was putting them each in a category. And one of the things that I've actually thought was most brilliant was we came up with a specific definition for each category. Some of these violations are actually category A through F. So, for example, conduct prohibited by law. So what you have to do then is you have to look at which definition does it best fit. And then that's the category that you choose. Others simply are presumptively within that individual category. So category A was conduct that has a minimal negative impact on the operations or professional image of the department. First violation in 3 years was a category 1, second was 2, third was 3. If you had more than that in a period of 3 years, then you would go outside the matrix. Category B, more severe. It has more than a minimal negative impact on the operations or professional image of the department, or negatively impacts relationships with other officers, agencies, or the public. And again, this goes now 2, 3, and 4 instead of 1, 2, and 3, and in 4 years rather than 3. So you can see one of them is discourtesy. So discourtesy in general was, and that's not the offensive language that Heather was talking about, which obviously would be much more serious, but in general, it would be a category 2. And if I actually go back and look, you can see category 2 would be a presumptive of written reprimand, or aggravated would be 2 fine days. But obviously, if you had a second violation, 4 years, or a third violation, the presumptive penalty is going to go up. Category C, conduct that has a pronounced negative impact on the operations or professional image of the department. And again, you'll see a list of various rules and regulations that apply. If you look at the bottom, there's rule and regulation 1004, testifying for a defendant. That was where you went and you testified for a defendant, but didn't let anyone know you were going to be doing it. So first violation in 5 years would be level 3. And one of the key things here is, again, we're not looking at some departments that what they say is, oh, well, we'll only aggravate, we'll only push up the discipline if you've previously done this before. And we said, no. Let's say you testify for a defendant, but previously you used a police position to gain political office. That's then aggravated. It may not be the same violation as long as it's as serious or more serious in the previous 5 years, you're going to be jumping up a level. Category D, this is where we get into the excessive force. The lowest potential level of excessive force. This is category 5, presumptive discipline of 10 suspended days, conduct that's substantially contrary to the values of the department or substantially interferes with its mission, operations, or professional image. You get to category E, again, much more serious violations. You're getting to a category 6 as a first violation, and I'll just head back here, and you'll see 6 is a 30-day suspension for category E violation. So, and again, it can go up to 7 or 8, 8 becoming along the most serious. Then finally, we get category F. And these are the ones which are presumptive termination with mitigation, might go down to 90 days, but it's a violation of law, rule, or policy which foreseeably results in death or serious bodily injury to anybody. So this would involve as well, accidental discharge that results in death. It's presumptive termination. It could go down to 90 days. If there's extraordinary mitigation, it could go lower. But it also includes, it constitutes a willful or wanton disregard of department values, or involves an act which demonstrates a serious lack of integrity, ethics, or character related to an officer's fitness to hold the position of police officer, or involves egregious misconduct substantially contrary to the standards of conduct reasonably expected of a police officer, or involves any conduct which constitutes the failure to adhere to a contractual condition of employment or requirement of certification. So these are all the most serious, which we agreed required presumptive termination. So basically what we ended up doing was we'd come up with a conduct category, which is sort of the preliminary discipline levels. We'd look at if the discipline history, does it need to be increased? We'd revise the discipline level and the presumptive penalty as a result. We'd look at mitigating and aggravating factors, and then engage in the weighing process and come up with the matrix penalty. Since we created this, and we created in 2008, so it's a long time ago, I was only able to find 4. Well, there are lots of other communities out there that have created matrices, not nearly enough, but I found 4 that were based upon the Denver model, which is what I highly recommend. I think you can take the Denver Police Handbook and matrix and you can make it your own. Although my recommendation is you do it with a group of stakeholders to make it to make sure that it really fits with your community and your department and it's accepted and understood by officers and community alike. Portland created theirs in 2014 and pretty much took big portions of the Denver matrix. Madison in 2018, Cleveland in 2019, that was part my doing, and Albuquerque effective April of 2023. So one of the most important things I have to point out is I tried this in Pasadena as the independent police auditor there. The chief of police was not interested. He's a very traditional chief and wants to be able to make the discipline his own and put the department in his own image, so to speak, or philosophy. I disagree with that. Chiefs come and go. I think it's really important that officers have the knowledge that discipline will remain consistent regardless of who's chief. We used to have in Portland, the chief would just write a letter that's saying, hey, everything's this, they were called clean slate letters. I'm the new chief and all prior disciplines are relevant because I'm going to make the decision. Great for the chief, not good for department, not good for the officers who are there for a career, who will then just wait out for the next chief because they won't accept what this chief's doing. So having a matrix that will outlast any particular individual but can be tweaked over time, that creates the kind of culture in policing that you really want, not just the ad hoc discipline imposed depending on who happens to be the chief. I just provided, I know I'm running out of time, I just want to take 2 or 3 minutes to sort of talk about the kinds of cases that we found were very helpful with matrices. I'm using an example of an officer drinking a shot of alcohol while on duty. This was at a birthday party, but we had very similar cases in Cleveland and in Pasadena. And in Cleveland, the officers were fired. It was considered category F. And in Pasadena, it was kind of considered, they didn't use the matrix, but really more category E. So again, great opportunity to think, okay, what would we want to do under this circumstance? Is this just absolutely inconsistent with an officer, expectations officer? Is this something where an officer can receive substantial discipline but still remain in the department? Off-duty arrest for impaired driving, again, this is a big argument. There's some people who think if we call it impaired driving in Canada, sorry. If you get a DUI as an officer, there are many people think you shouldn't be an officer. You should just be terminated. But what we have found is if you do that, officers never get arrested for drunk driving. So we made sure, if a first violation, most places were 10-day suspension, second violation might be 30, third violation 5 years would be termination. Others would say no, second one and 5 years would be termination. But again, you have to decide that. And then you have to think, okay, what if it involves property damage? What if it involves injury? What if it involves death? What about second or third violations in 5 years? So you have to think about that and decide what's appropriate for your department. And finally, I was talking about the big lie, little lie of Denver, officers lying to dispatcher about responding to a call. We said that was a little lie, really an unpremeditated lie. Whereas if they lie about the same conduct after being ordered to cooperate in internal investigation, that's a deceptive act, that's a category F, and that's presumptive termination. And then I've just got here, and I know these were prepared for everybody, but this is where you can find the disciplinary handbooks for Denver. Again, I think it's a great starting spot, but no city should just grab it, throw it in, and call it a day. This needs its process. You're trying to change culture. And in my mind, this is the best way to do it and have it stick. And perfect. I think
Okay.
that's up. So we're good.
Thank you so much. So we've got two questions in the queue, and I will read the questions aloud for the benefit of people who will watch this webinar via the recording, as opposed to being able to be here with us today. So the first one is, I'd be interested in the presenter's take on the function of discipline. Isn't it to, one, create in the mind of the disciplined officer an incentive to modify behavior going forward, and two, to set an example so that all other officers are incentivized to avoid misconduct? As such, isn't the key metric on sufficiency of discipline what will serve as an adequate disincentive? Seems to me the community expectation only comes into play if the discipline is showed to be ineffective.
Heather, I'm going to let you go first. I've been speaking a lot.
I mean, I think yes and no. I'm from a civilian oversight perspective, right? Not from a police department perspective. I think yes, both of those things are true. It is to disincentivize officers to commit misconduct, but I think, and maybe it's the former prosecutor in me, right? There is still an element of officers with this great responsibility that they have comes this great duty to hold themselves and to take these powers that they're given and use them appropriately. And so I don't think that a level of punishment is, I think it works hand in hand with disincentivizing that behavior. And I also think that the community is also entitled to understand from a civilian perspective, like what is really at stake here, right? Like what type of encounters, what are they going to face internally? Because we are one piece of oversight of officers, right? There's still the criminal avenue. There's still civil remedies that you can take. And so depending on what the civilian is looking for, that's important too, right? When I was prosecuting cases, sometimes a civilian was like, I just want to be heard. They just want to be heard. So it might be enough for them to say, listen, I get that all they're going to get out of this is, a day of training or something. But what they did to me was not okay. And I want to be able to say that, or I want to be able to prove that, or I want somebody to listen to me and also agree that that wasn't correct. And you're not going to get that for a discourtesy in the criminal justice system, because a discourtesy is not considered a crime, right? You're not going to get that in a civil proceeding, because it doesn't rise to the level of any kind of constitutional violation. So I think when we're talking about discipline and we're talking about internal discipline, I think it serves sometimes a different purpose. I think the two things you mentioned are correct, but I do also think there is a piece that does involve civilians and the way that the officers kind of interact with civilians and what civilians want to get out of the process and what's the best form for them to seek the remedy that they're looking for. So.
Right. And I agree with that. I just say also, modifying behavior, make an example for other officers. Those are important parts of discipline, but there's more. And Heather and I were both former prosecutors, and the reality is punishment is part of it. And I always loved it when I heard officers want punishment in the criminal system, but not in the administrative, when in fact it applies to both. And it's not just punishment, but it's Brady issues. Can this officer be an acceptable officer in the future? It's what is acceptable conduct to the community and to other officers. So that's, again, one of the reasons why I'm saying it really does need to be on a jurisdiction by jurisdiction basis, because you have to really figure out what is important in your community and in your department in order to keep an officer or not. And that's really been, excuse me, one of the biggest problems that we've seen is when officers are given a break and then, but within the overall community or even amongst other officers, people are rolling their eyes saying, why is this person carrying a gun and wearing a badge? And when they've done these things and they've already shown that they're not somebody that we can trust as an officer. So it's so much, yes, it's those two, but it's so much more.
And just to address, I think this person who made the comment made another sort of additional, I see here, termination equals no potential, not appropriate to seek to modify officers' conduct. As Richard was saying, though, like if I'm a prosecutor and you got terminated for making a false statement about an arrest that you made, I certainly don't want you making any additional arrests that are going to compromise my case, right? Like, even just from a public safety standpoint, you can't have officers out there who aren't trustworthy. And so sometimes termination is not necessarily just about you did something bad and you're being punished, but also like the police force can't afford to have officers who are making arrests and then the cases get thrown out. That doesn't help anybody either. So termination, a lot of times, especially when it's for the most serious, allegations, you're talking about you're killing people, right? Or you're severely injuring people, or you're lying. These are not people who can then go take the stand and be effective protectors of the community and be protective public servants. It's not going to work that way either. And it costs the department money, and it costs the department time, and it costs the department resources. And so I think there's an incentive for termination in the more serious cases as well. That's not just about, well, then they're not going to reform, then they're not going to reform their behavior. Some behavior, when you have a job like this, cannot be reformed. It's just part of the job. You can't step that far over the line, because then you just can't effectively even do the job anymore.
All right, and the questions are starting to roll in, and I know we're at the end of the formal webinar time. And so I have copied all of the questions to take to the discussion room. And so everybody, if for anyone who's interested in attending that, the link to the discussion is posted in, or I just sent it out via the chat to everybody. And so as soon as this webinar ends in a minute or so, if you click that link, you should not have to enter the passcode, but for some reason, sometimes some people are prompted to enter a passcode, so that is provided as well. But typically most people can just, yes, I will post that again. Typically most people can just, and I'll put it in the Q&A as well, so you can see it that way too. Hold on one moment. Okay, I just am posting it to the whole group in response to the person who asked to post it again. So you should see it there as well, but also in the chat. I do want to I have a couple of announcements before we end this formal part of the webinar. So first, the final webinar of the year will be Firearms 201. And that is a follow-up webinar to Dr. Thomas Webstone's Firearms 101 session that was earlier this year. So that is scheduled for Tuesday, December the 10th at 1 p.m. Eastern Time. Information about the webinar, including registration information, will be posted on the NAPE website, and we will send out an email blast reminding everyone of that. And then the other announcement is for anybody who is in the CPO program, and would like to get credit for attending this webinar or any of the other hours you attended, whether it was a webinar or the annual conference, please be sure to submit your hours by the end of this year, December 31st. Okay. I am going to log off in just about 30 seconds or so. I'm going to give everybody time to copy and paste that link, or just simply click it from your computer, and then I will meet you all over in the discussion room where everyone can see each other. So thank you, Heather and Richard, for presenting today, and thank you all in the audience for joining us, and I hope to see some of you in the discussion room in a few minutes. Okay, Heather and Richard, I want to make sure you're able to see the link and get over there before I let you. Oh, he's got it. Okay.
Yep, I got it.